6 words in your divorce papers might look harmless, the kind you barely skim over between clauses and signatures, but overlook them and you could be signing away your future without ever knowing it. Imagine waking up months later to discover you've waived every right to revisit alimony, inherited your ex's debts, or locked yourself out of any property you thought was yours forever. These aren't horror stories. They're real people who learned the hard way that legalese hides more than it reveals. In this video, we'll dive into the 6 tiny phrases that slip under the radar but carry consequences that echo for years. You'll hear true cases where those simple words became lifelong traps and learn the exact red flags to watch for before you ever put pen to paper. By the end, you'll know precisely how those 6 words can shift everything and what steps you can take to protect yourself today. Stay with me, because missing just one of these could cost you far more than you think. That one word may sound like legal boilerplate, but irrevocable is the ultimate power move in a divorce agreement. Once you agree that a clause is irrevocable, you're handing the court a locked door. No do-overs, no second chances, no ability to change your mind. Picture this: you and your ex agree on property division. You sign off on a final and irrevocable settlement. Then, 2 years down the road, your circumstances shift. Maybe you lose your job or incur medical bills you never saw coming. Under that irrevocable clause, you can't go back to the judge and ask for adjustments. What felt like a fair deal at the time suddenly becomes a rigid noose around your financial neck. Courts love irrevocability because it brings closure. No one wants a lawsuit that drags on forever. But life isn't static. Careers change, families grow, emergencies arise. Without the ability to revisit that agreement, you could be stuck with terms that no longer make sense, or worse, that actively harm you. Before you sign anything with irrevocable in it, pause and ask yourself, could I see myself needing to revisit this down the road? If there's any doubt, insist on removing or limiting that word, because once it's inked, it's gone for good. Waive all future claims might sound like a courtesy nod to moving on, but it's really a straitjacket for your future self. By agreeing to waive every claim, you're promising that no matter what happens next, job loss, health crisis, or a sudden change in income, you'll never come back asking for more. Think about that for a second. You're essentially signing away your right to fairness if life throws you a curveball. Maybe you discover hidden debts, face hefty medical expenses, or even see your ex's circumstances improve dramatically while yours crumble. Under this clause, you'd have no legal way to ask for additional support or property adjustments, even if you desperately needed it. In one real case, a wife waived all future claims only to be diagnosed with a chronic illness a year later. With her income gone and medical bills piling up, she tried to reopen the settlement, only to find the court doors firmly shut. Those 6 words turned a temporary hardship into permanent hardship. Lawyers often pitch this as finality and peace of mind, but that peace can evaporate fast when the unexpected hits. Before you agree, ask yourself, am I truly ready to walk away forever, no matter what's around the corner? If the answer isn't a confident yes, negotiate to carve out exceptions, narrow waivers to specific issues rather than an all-encompassing abdication of your right. Because life doesn't come with a guarantee, and neither should your divorce agreement. In full and final satisfaction sounds like the last nail in the coffin. Everything settled, nothing left undone. But buried in those words is a trap you might not see until it's too late. When you agree that an obligation is paid in full and final satisfaction, you're not just closing one chapter, you're slamming the book shut forever. Imagine signing away your right to correct even the smallest mistake. Suppose you later discover your ex misreported income, or you uncover hidden assets that tip the scales in your favor. Under in full and final satisfaction, you lose the chance to ask for a single penny more, no matter how clear the error. One couple thought they'd covered all bases until the husband's bonus checks showed up after signing. She tried to reopen the agreement, pointing out that those earnings weren't part of the deal. But the court refused. The phrase she'd glossed over meant never again, not for now. What felt like a neat ending became a lifelong barrier. Lawyers love this wording because it promises certainty. Clients feel safe knowing their pain won't be replayed in court, but certainty for one spouse often means inflexibility for the other. Before you let those words slip by, ask, could an unforeseen change make me want to revisit this? If there's any doubt, negotiate to replace final with a time limit or carve out specific exceptions, because final satisfaction should never feel like permanent regret. Hold harmless might seem like a safety net. After all, it says you won't be sued by your ex. But flip that coin and you're agreeing to catch any unexpected blows instead. In divorce papers, a hold harmless clause can saddle you with your ex-spouse's liabilities. Business debts you didn't know about, tax bills from years ago, even legal fees if they get sued down the road. Picture this. You thought you split everything cleanly, handed over your share of the house, finalized support payments, and walked away. Months later, the family business is audited, or your ex faces a lawsuit from a former partner. Suddenly, the court is calling you in, not your ex, to cover those costs because you held them harmless. What felt like protection turns into a financial ambush. In one case, a husband agreed to hold his wife harmless on all debts. When her small business was hit with a hefty judgment, he ended up writing checks for 5 figures, money he never earned and didn't even know existed. That 6-word promise shifted liability straight onto his shoulders. Attorneys often tout hold harmless as fairness. Why should one person pay for the other's mistakes? But it's a two-way street. If you sign it only one way, you're the one left vulnerable. Before you agree, pause and ask, could I end up responsible for bills or claims I haven't seen? If there's any risk, insist on striking the clause or making it mutual so both of you share any future liabilities equally, because a true safety net shouldn't have holes. Sole and separate property may look like a mundane label in your divorce settlement, but it can radically redefine what you walk away with and what you leave behind. When you agree that an asset is sole and separate, you're telling the court it's entirely yours or entirely theirs, no shared claims permitted. Sounds clear, right? Except that clarity can cut both ways. Imagine thinking you've secured half the marital home only to discover later that the deed was classified as your ex's sole and separate property. In one real-life case, a wife watched in shock as her husband claimed full ownership of their vacation cabin because sole and separate had quietly stripped her of any legal interest. She'd assumed their home was marital property, only to find that tiny phrase had rewritten the rules. It doesn't stop at real estate. Retirement accounts, business interests, even family heirlooms can fall under that label. If your 401k is deemed your ex's sole and separate property, those years of contributions vanish from your settlement. If a family business is marked solely in their name, you lose your stake, no questions asked. All because legal jargon convinced everyone it was already decided. Before you let those words slide by, pause and ask, could this classification leave me empty-handed where I thought I'd have half? If there's any uncertainty, negotiate to reclassify key assets as marital, or at least carve out percentages rather than handing over full control. Because sole and separate should never mean solely and unfairly. Binding arbitration might sound like a shortcut, a promise that you'll avoid a protracted courtroom battle in favor of a faster private decision. But what you trade for speed is your safety net. You give up the right to appeal, the right to a public judge, even the right to choose who decides your fate. Imagine agreeing to arbitration because it feels less stressful, only to face an arbitrator handpicked by your ex's attorney, someone whose decisions are final with no option to challenge a flawed ruling. One couple selected binding arbitration to save on legal fees. When the arbitrator awarded the ex a disproportionate share of retirement assets, the wife tried to appeal and discovered there was no appeal. Overnight, she lost tens of thousands of dollars with zero recourse. Arbitrators aren't bound by the same rules as judges. They can admit evidence you'd never see in court, and their decisions can't be reviewed for fairness or legal error. What starts as a convenience can become a trapdoor. Before you sign off on binding arbitration, ask, am I willing to accept a final, unreviewable decision even if it goes against me? If there's any hesitation, push to remove or limit arbitration to specific issues, or negotiate a clause allowing appeals on narrow grounds. Because a one-and-done decision isn't freedom, it's a gamble you can't afford to lose. Every one of those 6 phrases, irrevocable, waive all future claims, in full and final satisfaction, hold harmless, sole and separate property, and binding arbitration, might look like routine language, but each packs a hidden punch that can lock you into terms you'll regret for years. You've seen how a single word can slam shut any chance to revisit your agreement, saddle you with debts you never knew about, or strip you of assets you thought were yours. The takeaway is simple: never let boilerplate slip by without a second look. Ask questions, demand clarity, and negotiate carve-outs or time limits whenever you see those red flag terms, because when it comes to your future, good enough rarely is. Thanks for watching, and if this video helped you spot the traps before you sign, hit subscribe, share your thoughts in the comments, and remember, your best protection is knowing exactly what you're agreeing to.